Vitug vs. Court of Appeals, GR. Number 82027, March 29, 1990, Fax. On January 13, 1985, Romarico G. Vitug filed a motion asking for authority from the probate court to sell certain shares of stock and real properties belonging to the estate to cover allegedly his advances to the estate in the sum of 667,731.66 pesos, plus interests, which he claimed were personal funds. As found by the Court of Appeals, the alleged advances consisted of 58,147.40 pesos spent for the payment of estate tax, 518,834.27 pesos as deficiency estate tax, and 90,749.99 pesos as increment thereto. According to Mr. Vitug, he withdrew the sums of 518,834.27 pesos and 90,749.99 pesos from savings account number 35,342,038 of the Bank of America, Makati, Metro Manila. Rowena Corona opposed the motion to sell on the ground that the same funds withdrawn from savings account number 35,342,038 were conjugal partnership properties and part of the estate, and hence, there was allegedly no ground for reimbursement. She also sought his ouster for failure to include the sums in question for inventory and for concealment of funds belonging to the estate. Vitug insists that the said funds are his exclusive property, having acquired the same through a survivorship agreement executed with his late wife and the bank on June 19, 1970. The trial courts upheld the validity of this agreement and granted the motion to sell some of the estate of Dolores L. Vitug, the proceeds of which shall be used to pay the personal funds of Romarico Vitug in the total sum of 667,731.66 pesos. Court of Appeals held that the above-quoted survivorship agreement constitutes a conveyance mortis causa which did not comply with the formalities of a valid will as prescribed by Article 805 of the Civil Code, and secondly, assuming that it is a mere donation inter vivos, it is a prohibited donation under the provisions of Article 133 of the Civil Code. Vitug, the surviving spouse, assails the appellate court's ruling on the strength of our decisions in Rivera vs. People's Bank and Trust Company and McCam vs. Gatmatan, in which we sustain the validity of survivorship agreements and considering them as aleatory contracts. Issue: whether the survivorship agreement constitutes a conveyance mortis causa which did not comply with the formalities of a valid will as prescribed by Article 805 of the Civil Code. Held, no, the conveyance in question is not, first of all, one of mortis causa, which should be embodied in a will. A will has been defined as a personal, solemn, revocable and free act by which a capacitated person disposes of his property and rights and declares or complies with duties to take effect after his death. In other words, the bequest or device must pertain to the testator. In this case, the monies subject of savings account number 35,342,038 were in the nature of conjugal funds in the case relied on, Rivera v. People's Bank and Trust Co., SC rejected claims that a survivorship agreement purports to deliver one party's separate properties in favor of the other, but simply, their joint holdings. There is no showing that the funds exclusively belong to one party, and hence it must be presumed to be conjugal, having been acquired during the existence of the marital relations. Neither is the survivorship agreement a donation inter vivos, for obvious reasons, because it was to take effect after the death of one party. Secondly, it is not a donation between the spouses because it involved no conveyance of a spouse's own properties to the other. The agreement involves no modification petition of the conjugal partnership, as held by the Court of Appeals, by mere stipulation, and that it is no cloak to circumvent the law on conjugal property relations. Certainly, the spouses are not prohibited by law to invest conjugal property, say, by way of a joint and several bank account, more commonly denominated in banking parlance as an N or account. In the case at bar, when the spouses Vitug opened savings account number 35,342,038, they merely put what rightfully belonged to them in a money-making venture. They did not dispose of it in favor of the other, which would have arguably been sanctionable as a prohibited donation. And since the funds were conjugal, it cannot be said that one spouse could have pressured the other in placing his or her deposits in the money pool. The validity of the contract seems debatable by reason of its survivor-take-all feature, but in reality, that contract imposed a mere obligation with a term, the term being death. Such agreements are permitted by the Civil Code. The fulfillment of an aleatory contract depends on either the happening of an event which is, 1. Uncertain, 2. Which is to occur at an indeterminate time. A survivorship agreement, the sale of a sweepstake ticket, a transaction stipulating on the value of currency, and insurance have been held to fall under the first category, while a contract for life annuity or pension under Article 2021, et sequentia, has been categorized under the second. In either case, the element of risk is present. In the case at bar, the risk was the death of one party and survivorship of the other. But although the survivorship agreement is per se not contrary to law, its operation or effect may be violative of the law. For instance, if it be shown in a given case that such agreement is a mere cloak to hide an inefficacious donation, to transfer property in fraud of creditors, or to defeat the legit aim of a forced heir, it may be assailed and annulled upon such grounds. No such vice has been imputed and established against the agreement involved in this case. There is no demonstration here that the survivorship agreement had been executed for such unlawful purposes, or, as held by the respondent court, in order to frustrate our laws on wills, donations, and conjugal partnership. The conclusion is accordingly unavoidable that Mrs. Vitug, having predeceased her husband, the latter has acquired upon her death the vested right over the amounts under savings account number 35,342,038 of the Bank of America. Insofar as the respondent court ordered their inclusion in the inventory of assets left by Mrs. Vitug, we hold that the court was in error. Being the separate property of petitioner, it forms no more part of the estate of the deceased,